attorney at law, Mr. Sookoo. Pleasant good evening to you, Joseph Sookoo. How are you, sir?
I'm great, MikeeK. I'm great.
It's a pleasure to always have you. All right. No audio. Yeah, just run that up for me, please. Okay. Let me ask you, first of all, as far as rent, what are the legal factors that make up a rental agreement?
Well, like any other legal agreement, leases, these sort of things, basically the parties have to intend to enter into such an agreement. They have to agree on the terms, and depending on the length of the lease, there are certain statutory and legal requirements, such as registering the lease, and these sort of things. Oh, and one last thing, of course, if you have a lease involving the payment of rent, in most cases, if not all, you are entitled to occupy that property without interference from anyone, including your landlord, except in default.
Quite interesting. But what are some of the common problems you see as attorney between tenants and landlords?
Well, as between tenants and landlords, normally the biggest issues come from the tenant side. In most cases, they don't pay their rent, or when they're leaving, they commit damage to the premises that the deposit either cannot cover, or even that the deposit has been used towards rental payment. On the other side, with respect to the problems with landlords, there's very often the problem of landlords trying to withhold the payment of deposits at the end of the lease agreement. In fact, I'm dealing with one of those situations right now.
Yeah. But in a situation where, for example, what happened with this apartment that was burned down, now the rental agreement has not been renewed. It wasn't renewed, but the tenant was still occupying the apartment. Is he or she still responsible for any damages?
Wow. Well, it really all depends on the nature of the original rental agreement. Now, forgive me for giving you a little bit of background to how this goes.
Go ahead.
Any arrangement between any two parties, contractual or otherwise, can be in writing or be oral, right? With land transactions, and a particular rental transaction, there is a circumstance in law where if a written tenancy or a fixed tenancy comes to an end, that tenant continues to occupy and continues to pay rent, they are regarded as a, if you will, a periodic tenant. That is, let's say you're paying rent month to month, you're regarded as a monthly tenant. If you're paying annually, you're regarded as an annual tenant, in the absence of any other specific agreement extending the original agreement.
Yeah, but okay, go ahead. So,
in such a circumstance, what we have to do is look towards the original agreement, because those terms continue while the person occupies. Now, if the original agreement between the tenant and the landlord in this circumstance, I would suggest, and there's a lot of little details in there that we aren't necessarily privy to, involves liability for the tenant in the event of doing damage to the landlord's premises. The tenant is a problem. Sometimes, however, it may very well be a fault in the premises themselves. We don't know. It can even be the act of a third party, in which case, well, it's a sort of everyone stands their law scenario.
But you didn't give back the key. You've been paying the rent. Now here it is that the rental agreement has expired. Isn't there some sort of oral or some understanding that, okay, the terms and conditions still apply and you still have responsibility for any damages?
It all depends on the nature of the original contract and the type of damages that occur. The example, if a random person, a vagrant or some other malcontent, and I'm not suggesting a vagrant or malcontent, but let's say someone who's unpleasant, shows up and, burns the place down, you can't blame the tenant for it, nor can you necessarily blame the landlord. That's an act that isn't normally covered under a rental agreement. If, however, for example, the tenant caused the blaze or caused damage, normally the original agreement, the terms of which will continue whilst that tenant is renting. In that circumstance,
So let me ask you this. Now, as far as, let's say, an insurance agreement is that if I take insurance out on my car, then I am the insured driver. If someone else was to take the keys and drive that car, I will still be responsible for any damages that they do. Am I correct? Because it has been insured in my name. Am I correct?
Ooh, well, you just stumbled onto an issue that was resolved several years ago by the Privy Council. The question then becomes, who gave permission for that new driver? Right? Permission matters. Responsibility matters. So if in that particular case, if the new driver drove the car with the permission of the owner, then of course the owner is responsible for the act of who we call the agent. But let's say that that car was stolen. I mean, the insurance coverage doesn't necessarily cover the thief who stole the car.
Okay. All right. So in this situation, okay, I'm still renting, but somebody comes over. Let's say a lady friend comes over, and she burns down the apartment. Does she become responsible, or is it because it's been the terms and conditions of the contract is in my name? What happens then?
Well, if you invite someone to your premises, you are responsible for their action in most cases. So in this scenario, you invite your lady friend over, you have a time, you're maybe smoking cigarettes afterwards, and the cigarette causes a fire. Well, that's on you, right? You brought the person there, you're responsible for their action, you take liability.
And even if it is that, okay, and again, kind of cloudy here, but I'm glad that you're clearing this up for me. So you still have the key, you're still paying the rent, which means you're still occupying the apartment. Someone comes over, a friend of mine, they burn down the apartment. You still have to go back and make reference to the original agreement, or automatically I am responsible because I am the one occupying it under my name?
The answer to that question, MikeeK, is both. Because ultimately, regardless of the original agreement, and you start there first, regardless of the original agreement, you still have common law duties towards other people and their property. So even if the agreement doesn't cover it, right, in a circumstance where, let's say, it was deliberately negligent or, deliberate in a malicious sense, then, you don't escape that liability because it's not in your lease. You caused it, you did it. The landlord can't be, out of hand because of something you did. You can go past contractual liabilities into the realm of civil law and tort.
So basically,
it's an interesting dynamic in that regard.
So should there have been an indemnity agreement then?
Now the indemnity is even more interesting. Now, very recently I did a case where someone claimed an indemnity because of acts caused by a third party under their watch. That is legally possible. So in the same example involving the lady friend, potentially you can seek to have that lady friend indemnify you as the occupier and tenant as against any losses that are occasioned by her action and that you are responsible for. Realistically though, that's a legal argument that becomes a little bit more ticklish when you consider whether or not people generally have the means to satisfy legal judgment and liabilities and damages and all these sort of things.
So with this indemnity agreement, is it that she simply just walks away and I take full brunt of everything?
Well, if in this particular case, let's presume your lady friend, is driving a brand new Mercedes and has some means, then I would say bring her in the action, if there is one. Say, listen, I invited you here, but you caused this damage. I am going to come after you to recompense me for whatever happened. And if she doesn't want to pay, you take her car, you take her bank account, you take her house and land, and you see where it goes.
All right, so definitely. So she's not off the hook whatsoever.
Not if you do it right.
Not if you do it right. Is there a price to pay if, for example, the contractual arrangement has lapsed? In good faith, the landlord said, because we saw so much of that taking place in the heights of the pandemic. Okay, 2 months, 3 months, 4 months. and the person just said, listen, I just can't pay, and they up and leave. Is there any redress whatsoever for the landlord?
Yes. Okay, so one, the COVID pandemic, while unfortunate, I honestly think it's still ongoing, has not been recognized in any common law jurisdiction. We're talking England, states to a large extent, anywhere we can really think of as a reason to vary or change the terms of any contract, including leases. What has occurred, though, is that there's a commercial factor, a practical factor. People aren't working, people can't do this. People change the term amongst themselves. There is no compulsion on anyone to simply arbitrarily, I won't say arbitrarily, that's a bit unfortunate, but to simply decide that, listen, yes, it's a bad situation, I am not going to pay, I'm going to leave. And as it stands, at least in this jurisdiction, if you have a lease agreement, you pay your lease until it comes to an end, and if you break that lease, then the terms of that lease in the event of default apply. You can't just up and leave and don't pay your rent. You're going to have some problem.
But you know, it always seems to be so painstaking for, you know, landlords to say, listen, man, to go through this entire process, and then I have to go to court, and you know, while I'm doing all of this, I lost out on revenue because I couldn't rent out the apartment, and it always seems as though there are more rights for the people who put you in an inconvenience than you who own the space.
I understand what you're suggesting there, but let me flip that on its head. You want to engage in the business of renting properties?
Right.
They are. You know, just like every other business, if you're selling car parts, you know, or you're engaging in construction, you're going to have sometimes bad clients and bad customers. And what are you going to do? You're going to sue them. You're going to take a business decision, determine whether the juice is worth the squeeze, and figure out, listen, am I willing to take this loss or not? But that is the nature of the business.
Yeah, and I think what you're saying too is stick to the nature of the business and don't buy into sad stories. You may want to help, but sometimes helping costs you more in the long run.
I can't necessarily say that, because I can tell you that during the pandemic, when, for example, some of my colleagues were looking at high rent in Port of Spain for their offices, a lot of them negotiated with their landlords to reduce the rent. Sometimes, you know, one needs to look at the value of a continued relationship with an existing customer, an existing tenant, than the cost and effort it costs. So you would accrue opportunity loss, I think it's called, in getting and creating new relationships. You know, I would say, listen, do your best, people are people, and understand that sometimes it's worth just as much continuing an old relationship, even more so than creating a new one.
You know, Joseph, you are a great attorney, but based on what you just said, I know you wouldn't make a good banker. So you're in the right field, trust me, because you're talking about having a heart. So you're good as an attorney, but I know you wouldn't make it as a banker, my dear friend. Closing comments, go right ahead. What should we look out for? Go ahead.
I say, listen, at the end of the day, we've gone largely past the COVID pandemic. There are no reasons for landlords to change their tenancy agreement. There are no good reasons whereby a tenant can leverage a landlord against their tenancy agreement. Listen, the game is back to how it's played. So, do your business, do it properly.
Thank you so much, Sookoo. It's been a pleasure as always. Keep up the good work. All the best to you and your entire team. Thank you so much.